Hey, everybody, welcome in once again to another edition of Your Heels on the Ground with Ellen Mitchell. I'm Bruce Silverman along with Ellen Mitchell and Sharon Walker. She is the attorney extraordinaire along with the probate realtor extraordinaire, Ellen Mitchell. And Ellen, I'm going to let you do the introductions once again for Sharon because you did such an amazing job on the last episode we did with Sharon.
It is not difficult to introduce Sharon because Sharon is a rock star. Sharon is an attorney, a real estate attorney, both in Florida and Jamaica. She's somebody that I use for my buyers and my sellers. She is an incredible real estate attorney who often is able to find errors on the closing statement and able to save the clients money that they were being charged that they shouldn't. And rather than bringing in a real estate attorney, if something goes wrong, better to have her in from the beginning, looking over everything and taking care of my clients. So very happy to have Sharon Walker here today.
Thank you so much for your kind introduction. I'm so happy to be here.
Time for us to jump right into it. We got two great topics today. We're going to start with this one. Seller not following the contract and jeopardizing the closing. I know from personal experience, I've had this when it's had nothing to do with probate. Just the seller decides to, pack some of the furniture you decided to buy or doesn't remove some things from the property that you didn't want on the property and you don't want to be responsible for taking care of it. I might have just jumped on the punchline a little bit with what you guys want to discuss, but that was actually some things that I had gone through. So Ellen, I'm going to let you set the table on this one about some examples that you have had where the seller is doing everything possible to blow up the deal.
Thank you, Bruce. You're right. This happens in both probate sales, senior relocation, traditional sales, all kinds of sales. And we really try to educate the seller that the contract dictates that the property has to be vacant in broom swept condition, which means clean. And I let the sellers know time and time again through the closing, okay, you need to have somebody remove all of the personal property, everything under the kitchen cabinets, the bathroom cabinets, everything has to be empty, nothing left in the garage, nothing left outside. And, I offer to have people come in for donation, for auction companies, to trash out whatever they need. And sometimes they just, I guess they don't believe me. And Sharon and I had an occasion a few months ago where the gentleman had a lot of pavers for his patio. Typically, usually a buyer would want that. So I asked the buyer's agent, would you like the seller to leave the pavers because they're additional pavers for the deck and patio? Buyer didn't want them. I said, I'm surprised, but unfortunately the buyer doesn't want them. You're going to have to remove them for closing. And the day before closing, we went to the walkthrough. I went to the walkthrough, and there were hundreds of pounds of pavers. And I did ask the buyer's agent again to ensure that the buyer doesn't want them, because now it was going to be challenging to get them removed by the next day. Buyer doesn't want them. And so we were able to have somebody who we work with a lot come in at the last minute because of my relationship with them and remove all of the patio pavers. But it cost the seller more than it would have cost had it been scheduled in advance. We probably could have donated them and had them go to somebody else on OfferUp or Facebook Marketplace or a million other places. But this was the day before closing, hundreds of pounds of pavers that we had to have removed. Otherwise, it would have delayed the closing. The buyer would not close with them, and they were getting a mortgage. Their rate lock was expiring, and it would have cost the seller a lot of money to delay the closing. Then recently, as of 2 weeks ago, I had another closing. I had the same discussion, except the things that they left weren't as
Heavy,
as interesting or valuable as that one. It was just a lot of stuff left in the house and in the backyard and big planters and heavy items. And thankfully, I again did the walkthrough the day before. saw all of these things and had to call someone to come out, remove everything, and clean the property because it had to be left in broom swept condition. So it's really great when your clients work with you and get these things done ahead of time. It'll save them money and time and stress at the end. But it's one of the reasons I like to do the walkthrough the day before closing as opposed to the day of closing, so that if there is anything, at least we have a minute to have our referral partners jump in and take care of things and not to close.
Sharon, how difficult does a situation like this and others make your job where tensions are high, emotions are high? As Ellen was talking about, a rate lock was about to expire, and everyone is on edge, and your job is to help make the deal go through.
Well, let me tell you, it can get very touchy and very, very stressful. But with Ellen on board, I have to say, she has kept me with that other transaction we were referring to up to date, because she was able to continue to remind the seller that these are the responsibilities and the liabilities if it does not occur. And I also explain the same thing too, but it gives me the opportunity to, from a legal standpoint, try to ensure that we stay within contract, because that is a deadline that if we miss, we're now in breach of contract. So while we're continuing, and I have Ellen with her heels on the ground trying to move pavers, I'm on the other end dealing with the buyer's attorney and the buyer's closing agent to try to facilitate a creative alternative, whether it's by way of executing a credit on the closing statement or additional time to move the pavers, or hold an escrow until the pavers are moved. And if they are not moved, then they are entitled to those funds. So we try to creatively get to a point where we're not out of contract and that my client is not in default, while Ellen is on the other end, like I said, moving pavers in heels. And I have to say, she says the day before, but it was the evening before and the morning of, they were still moving papers.
Okay, moving right on. What are the risks when not disclosing structural issues? Now, obviously, this is from the seller's side, but when those are discovered and they haven't been disclosed in advance, what are the types of scenarios that come up that have to be addressed and overcome?
I'm going to punt this to Sharon. We just dealt with this maybe 2 weeks ago, so she can share with you what a fun adventure that was.
So it's a fun adventure because sometimes sellers don't like to show you the flaws of their lovely home, and they tend to take things like cosmetically painting and doing little structures, etc. But once a seller knows that there is a defect, or that there has been a flood, or there's been any kind of structural issue that could compromise the property, they are required to disclose this by law. Also, once a realtor is aware that the property has structural damage, they are also have an obligation to make a disclosure or to not represent otherwise. In the scenario that we had, Ellen was not just the realtor, she was actually the seller in this particular transaction. She was a former owner of a property, and she has transferred over the property, or basically sold the property approximately 3 to 4 years ago because of the concerns with the structural issue that was on the property. They actually had an engineer go out. They had a foundation specialist go out who gave assessments to state that, yes, this is a problem and it's going to continue. Based on the difference between her opinion and her co-owner's opinion at the time, she decided to sell her share because the co-owner was not willing to fix the issue. Fast forward now, the co-owner has now listed that property for a significant amount of money more, and they had to reach out to us because they required seller as a prior owner to sign additional documents that they needed to clear title. And at that point in time, Ellen brought it to my attention and mentioned that she doesn't think that this has been disclosed to the new potential buyers. We did inquire with the attorney as to whether or not her clients were aware of a possible foundation issue. This was actually the day of closing. And the buyer's attorney basically stated to me that they were not aware. They had requested an inspection and they were told everything was fine. and they were not aware that she had painted over possible cracking of the foundation, etc. So Ellen was kind enough to provide me with a copy of the engineering report she received 3 years ago. I provided that to the buyer's attorney, and the deal was immediately halted. The co-owner, the seller, did not want to allow them to have an engineer come and reassess. So at this point in time, that deal was completely canceled or terminated. So we've saved that buyer over hundreds of thousands of dollars of cost to repair the structural damage that was occurring and continuing to occur.
Now, and this is a question for both of you. If you go to sell a property and you're the buyer and you want to have an inspection done and the seller says, no, I won't allow that. That to me would be an immediate red flag. But once you're under contract, can a seller refuse for the buyer to have the property inspected?
So the buyer actually did an inspection, but the defect was covered up. So when they did the inspection, everything appeared okay. But when they got the information, they said, we would like to go in and have a structural engineer inspect it now that we have this information. And the seller, my former partner on the property, said, absolutely not. So you only have an inspection period in the contract of 7 days or 10 days. That time period had passed. She was within her rights, allowed to refuse an additional inspection, but she was not in her rights to not disclose any known material effects that are not readily observable to the buyer.
Correct.
And obviously, she knew that there was a defect, which is one of the reasons why you got out of the property, but never took the opportunity to fix it.
Right, because when we owned the property together and I suspected based on cracking that there was some settlement and I had the inspections done, I said, okay, we're going to need to take care of this. And her reply to me was, well, let's just paint over it. Let's caulk it. And I said, I'm not concerned about the visual defect. I'm concerned about the structural defect. And she completely disagreed. And I said, I'm not interested in owning a property that's settling, and that's going to continue to happen. It's not going to stay, where it is. I'm not interested in owning a property with this kind of damage and not addressing it. It's only going to get worse over time. And so she bought me out at that time because I didn't want to continue with ownership for that reason.
So I've used the term passionate and compassionate for you, Ellen, and now we'll just add ethical on top of it.
Thank you.
Another great discussion, more topics that buyers and sellers need to be aware of, need to address. In this particular case, a little bit of buyer beware. And I guess that buyer has you to thank for not purchasing a structure that potentially was unsafe and potentially would have cost tens or even hundreds of thousands of dollars without any way to recoup what would have taken place and probably would have ended up in a very costly and drawn out lawsuit between the buyer and the seller in that particular case. Sharon Walker, Ellen Mitchell, I'm Bruce Silverman. Your heels on the ground with Ellen Mitchell. We'll see you on the next episode.